We have Jim Sutton who is going to be able to share all the details of this new legislation, and Matthew Alvarez. Whenever we have a question here at the BIA on anything regarding elected officials or the electoral process, we call their office and we get the best advice, and they are able to make sense of it all. So today, Matthew and Jim, can you make sense of SB 1439 for us?
We're gonna do the best, the absolute best that we can. And let me share my screen here. Great to see everyone. As Lori mentioned, my name is Matthew Alvarez, and my partner Jim Sutton. We're attorneys with the Sutton Law Firm. We specialize in political and election law, and we are intimately involved with giving advice about this particular law that we're going to talk about today, and all of its different complications. So I'll do a quick overview, and then Jim will give you some detail and background about the law, including the state BIA's lawsuit, and then I will go over the intricacies of the law, and I will just say, everyone feel free to interrupt us with questions. We can certainly talk at everyone for an hour, and that would be somewhat informative, but we've done this a few times now, we find that when people have questions, just interrupt us with questions, and it tends to be a more robust discussion, and people get even better information. Again, this is for you all, so every question you have, we want to be able to answer and give you the biggest bang for your buck here on this call. So Jim, take it away.
So I guess my first kind of comment is, don't kill the messenger. Right. Matthew's going to talk more about the specifics, but I guess part of my job is protecting Matthew from all of you. So the law went into effect January 1st. And what makes this kind of interesting for us, we've worked with clients on quote unquote new laws. I mean, that's part of what lawyers do, right? But this is really an extension of law that's been on the books for 40 years. The Levine Act, which currently, and even before this law, applied this $250 limit on contributions to planning commissioners, coastal commissioners, other members of state and local appointed boards and commissions. That's been on the books for 40 years. The FPPC has been giving advice about all these nuances. There's a whole, 20 pages of regulations out of the FPPC about this law. And all the law did was amend who it applies to, not just planning commissioners, the Coastal Commission, other appointed commissions. Now it applies to local elected bodies. But so again, a lot of the questions that have come up have been asked and answered, and a lot of the ambiguities have been resolved. I think it's also interesting and important to know where this law came from and why it got passed. And the bottom line is everyone was asleep at the wheel, right? That Common Cause has put forward this law several times over the last 10 or so years. But it just kind of dies the kind of slow death that these things normally die in the legislature. Here, if you look at the legislative history, there's one short staff report that describes the law, and that's it. And that staff report gets repeated. As Matthew will talk about, there's a California Supreme Court case from 1980 that says that elected officials are allowed, as a matter of First Amendment law, to vote on matters affecting their campaign contributors. So that case, say what you want about that case, it's relevant to SB 1439. That case is not even mentioned in this staff report. There are a list of supporters, Common Cause, League of Women Voters, the usual suspects, no opposition whatsoever, either by name, by letter, absolutely nothing, passes unanimously out of both houses. And then I think that the shock of everyone that the governor signed it. And, we spent a lot of time trying to figure out where this came from. There was a controversy in the city of Baldwin Park in the east side of LA about some kind of contract over cannabis permitting, so, a marijuana club. And both sides threw a lot of campaign money at the city council. It was a big controversy in Baldwin Park, but Common Cause used that, got to Steve Glades to the legislature, and certainly the law goes well beyond permits with cannabis operators in small cities. What's important about this law, kind of the scare tactic, is yes, it can lead to FPBC fines, and the FPBC has levied fines against people for violating Section 84308 for years. City attorneys and even district attorneys can enforce it also. But really, more notably, it kills your votes on the council, right? Because there is this disqualification prong that if a real estate entity or their agents or participants give more than $250 to a council person during the 12 months before the vote, that council person, who you presumably like, if you're writing him a check or her a check, can't vote on your project. So that's obviously what has everyone spooked, that the kicker is bigger than it is with other campaign laws. And also what has happened a lot over the years with this law is the press coverage is often worse than whatever the monetary fine might be if you accidentally trip up. And even if disqualifying one council member doesn't matter, but the press is going to be about corruption. The press is going to be, this real estate developer was trying to bribe the council person, even if we all know that's not true. And even though you can't really bribe a council person with a $500 contribution anyway. So there truly is a lot of downsides to the law and a lot of reasons to take it seriously. So the only other kind of general background thing I'm going to talk about before Matthew gets into the specifics is there is finally a lawsuit. It's primarily California BIA filed the lawsuit. Tom Hilltack, their attorney, I've kind of been in touch with at all steps of the process, but there are several other trade associations, the Business Property Association, the Business Roundtable are named plaintiffs. And the hearing is on May 25th in the afternoon in Sacramento. A good judge, Japanese-American judge, who used to be at one of the big law firms in Sacramento. Everyone speaks highly of him. And Tom's not worried about the judge per se. So there's both a substantive argument in the lawsuit and, interestingly, a procedural argument. So the substantive law argument is basically the First Amendment, right? That is the California Supreme Court case, the Woodland Hills case, that elected officials have the right to vote on matters affecting their contributors. They, in fact, do it all the time. And kind of as long as we have privately financed elections in America, you can't effectively prohibit contributions. And then a lot of other, Tom did a good job. There's a certain amount of throwing it against the wall and seeing what sticks going on. That the 250 is too low. It was a limit that was set over 40 years ago. Campaigns are more expensive. That because it's novel, because this law has never been tried in California, the legislature needed to hold specific public hearings on it. So they've really kind of put out every substantive First Amendment argument as possible, but also a procedural argument, which could be very strong. So the state law, which has 84308, the current law, has all the state campaign laws, the state lobbying laws, the state gift laws, was passed by initiative in 1974 after Watergate, Prop 9. And it says this law can only be amended by another vote of the people. Now, the legislature has passed dozens of amendments to the Political Reform Act, but they're all clarifying, right? They're all like updating for new types of communications, clarifying the definitions of proceedings, those kind of things. So the argument is, when the voters adopted this law, they effectively said, you can trigger someone's disqualification based on a gift. You can trigger an elected official's disqualification because of their source of income, but you can't trigger disqualification because of a campaign contribution. You can for appointed commissioners, as I said, but you can't for elected officials. And therefore, this required a vote of the people. It's an interesting argument. It's kind of unclear what types of amendments to the PRA rise to the level of requiring voter approval, which ones don't, and that's I think going to be argued before the judge. But again, an interesting non-substantive argument, as well as the more substantive First Amendment argument. And And just for the lawyers in the crowd, procedurally, the way Tom and the state are doing it, it's cross motions for judgment on the pleadings. So both parties filed briefs at the same time. That allows for kind of more arguments, more briefing. They're filing their reply briefs a week from today. And then the hearing is, I guess, the week after that. And we'll obviously be there and with fingers crossed. So, so again, if anyone has any questions about kind of how this happened or the lawsuit, feel free to ask now. If not, Matthew will kind of jump into it.
Great. Yeah, any questions, any hands up? Okay, so let's just dive into the law. And again, feel free to interrupt us with questions, you know, as we go along. So first thing, as Jim alluded to, oh wait, I see a question from Craig. We want to just.
Yeah, thank you, Matthew. Sorry, Jim.
Go for it.
How you guys doing? I might have missed it, but do you think the FPPC holds off in doing their final, you know, I guess, resolution on all of this or their final guidance on this until after the court case is resolved? Or do you think it happens before then? Seems like they're moving that direction to do it before then, but I'm kind of curious what your thoughts are on that.
So as some of you know, the first controversy was, does the law apply to contributions made before 2023? And the FPPC wanted it to apply retroactively, but the staff did, but the commissioner shut them down. So that's been done. So the FPPC proposed regulations, but you know, we've gone through them. Frankly, they're nothing, right? That they're regulations that have been on the books for 20 plus years that kind of flesh out a lot of the details of the law. What the FPPC has proposed is basically just updating those regulations with kind of wording changes, adding into the regulations that it now applies to local elected officials. But the FPPC regulations, they're scheduled to consider them next week. And will they wait? They probably won't, right? I think we've not heard that they're not moving forward with that. But again, the regulations really aren't substantive in any way yeah.
Okay, so as Jim alluded to, you know, the law now covers all elected bodies: city councils, board of supervisors, water districts, transportation districts, school districts. You know, if you need approval from any of those boards, then you know you need to be paying attention to this law and the campaign contributions that you're making. Now, the state folks, of course, you know, carve themselves out of the law, right? So it's a sitting assembly person. You can give to that person, and it doesn't cause any problems. You know, same with federal candidates. If you want to give to a federal candidate, that doesn't cause any problems. It does cause a problem if, just for instance, you have a project coming before your city council or the board of supervisors in the next couple months, and that person has announced that they're running for state senate, or they're running for assembly, or they're running for federal office. If you do make a campaign contribution to their federal campaign committees or their state campaign committees while they're currently elected to that city council or to that board of supervisors role, this law does kick in. So you have to be very cognizant of who you are giving to and what their current status as an elected official is, and what and what they're running for, right? And so that's new, right? The old law, you know, is still in effect, right? Just, you know, for instance, the lieutenant governor, you know, she's announced she's running for governor. She sits on the lands commission. If you were trying to buy a piece of property or sell a piece of property to her from the state, and you made a campaign contribution to her governor committee, then she wouldn't be able to, she wouldn't be able to vote on the sale of that piece of property. That's old. That's the way it's always been. You've always had to care about that kind of stuff. But of course, previously that only really came up in very limited circumstances. Now, you know, the broadness of this law comes into full effect. I see a question from Marco.
Yeah. How does elected city attorneys relate to this? And they're not necessarily a voting person, but you're negotiating agreements with them, and ultimately they're making some sort of decision.
You know, that's a really good question. I mean, you're not allowed to, as an elected official who receives a campaign contribution, you're not allowed to I mean, city attorneys don't have votes or anything like that, but they are in a sense participating in the matter, and they're not allowed to participate in the matter. So you do need to pay attention to that, right? A city attorney is gonna, if they have a role, whatever their role might be in the approval of your project, if you make a campaign contribution to them, then they, in theory, they need to not participate. Now, that doesn't flow down to their staff, right? So if it's the elected city attorney and they are involved in your project, giving a campaign contribution to them, they would need to not participate, but it doesn't flow down to the staffers, the deputy city attorneys doesn't apply to the whole office. Does that make sense, Marco?
Yeah.
Great. So yeah, so I mean, it's conceptually, it's a lot to take in, but it's not particularly complicated. If you need approvals from an elected body, this law is something you need to be, paying very, 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 very careful attention to.
Matthew, I'm sorry, could I follow up on that?
Sure.
The question is, even though it doesn't flow down to staff, the city attorney has to sign off on everything, right? So does that mean the city attorney could avoid signing off and a deputy city attorney could sign off so that approval is valid, or how would that work?
So, actually, it's really only gonna apply to a city attorney in those towns that have elected city attorneys, if that city attorney is running for office, because it applies to local elected bodies, and the city attorneys are not on those bodies. So we had a situation with some small Southern California city where the elected city attorney is raising money for council, to run for council. But that's the only time it's really gonna happen. The law.
Yeah, Jim, we have one in San Diego, as you know, and we have a termed out city attorney and one deputy city attorney running and a sitting assembly member running for that office. So it is relevant here.
Right, exactly. Yeah. So
just to clarify, in Chula Vista, they're about to have a city attorney election, and it's going to be somebody who's not a sitting council person or somebody who would in the near future run for a council position. They're just running for city attorney. Can we give money to that person?
So you can give money to Mainshine running for city attorney, because he's not running for a local elected body, and that's not going to impact him. And Chula Vista, I don't know who's running in Chula Vista.
We don't even know necessarily who is running, but it doesn't look like anybody who's sitting in an elected office will be running.
Yeah, then there's not going to be a problem, because they don't sit on a body. So.
But Jim, to clarify for Mainshine, I'm sorry to keep jumping in here, but to clarify for Mainshine, it's not relevant except to when it gets to within 12 months of when that person might be seated, then it could be relevant to them, right? Because of the retroactivity of the law, that look back period of 12 months.
No, it doesn't. The law only applies to members or candidates for local elected bodies, city councils, boards of supervisors, water districts. There's some local transportation districts that are elected. That's all it applies to, right? So I think some of the comments might have been too broad. So it's never going to apply to Mainshine and city attorney ever.
He's
right?
running for city attorney though.
Right, but it doesn't apply when you're running for city attorney. It only applies if someone's running for city council or board of supervisor or water district, or
you need to be a part of a body. You need to be running for a body.
Right. So you either have to be running for a body, or you have to be a member of a body who's running for something else to have it apply. So Mainshine is totally in the clear, and so is the deputy city attorney also, who's running. I can't remember.
Well, that'll be news to him, Jim. You should call him and get him as a client, because he thinks it does apply to him.
Yeah, no, it doesn't.
There you go. Let's let Matthew get through the overview.
Yeah.
No, this is good. This is all good stuff.
These are good questions.
Then obviously moving on to what the law actually applies to, right? It's, all land use deals, license, permits, other entitlements for use are covered, really essentially any portion of a real estate development which requires any type of local elected body's approval. So that's everything from the big stuff like a development agreement, with a city or with the county, all the way down to a street vacation, right? you know, and even if the matter itself is, you know, a consent item on a city council or board of supervisors, right? It's a small, right? They're just, you know, making a public right of way into a private right of way, something that, you know, usually ends up on a consent calendar, isn't even debated. It still counts as an official vote, and, you know, you need to watch out for that, because, you know, even the small stuff that needs approval for your projects, you know, can very likely trigger this rule.
So I've got to interrupt because Tom Hilltack, the attorney for BIA, I spoke with him last week about the reply brief, and there was an article about what it covers, and he's going to use this article in his reply brief. There's an article in the San Francisco Chronicle within the last couple of weeks about a woman had put up one of those little free library, like looks like a mailbox, you know, like inside her house. There's like a little wooden box that she decorated, and you put books in it, you take books. I mean, they're all over the place, right? Well, of course, only in San Francisco, some neighbor complained, oh, and the little free lending library thing blocks the sidewalk, and the city sends her a notice that she has to apply for a permit. Which again, only in San Francisco. But Tom's making the argument in terms of overbreath. Yeah, that woman now cannot give to a San Francisco supervisor because she has to get a permit in order to have this little lending library box on her in front of her house. So anyway.
So yeah, so that just highlights kind of how, you know, you know, even the tiny issues, if they need some type of approval from an elected body, you know, they will trigger this rule. The other thing that we've gotten a lot of questions on are about appeals. So right, so you get your approval at staff level, or you get your approval at planning commission level, and there's some type of appeal. You know, if it's an automatic appeal, right, you know, like under all circumstances, it's going to get, you know, it goes to the elected body, which at least in our world, I think is rare, an automatic appeal. You know, then this rule is something you've got to pay attention to, you know, from the inception of your project, even though, you know, it really should just be a planning commission or staff level approval. The appeals that your opponents file when, you know, you've gotten that staff level or you've gotten that planning commission level approval, once that appeal is filed, this rule goes into effect, right? So then if you've made a campaign contribution, we'll get into timing in a second. If you've made a campaign contribution to an elected official who's gonna rule on that appeal, now you made it before the appeal was filed, the contribution itself isn't illegal. The solicitation that you received from the, you know, elected official, that wasn't illegal, but it would trigger disqualification unless you get a refund, which is, again, we'll talk about. But you know, appeals have their own, you know, they are something that kind of is tricky with this law in terms of timing and in terms of when you can get a refund and all those things. So, but again, you know, appeals definitely trigger this rule. If you know, if all of your approvals are ministerial, they don't require any discretionary votes at all, right? So they're all staff level. And you're not going to ever need to go for a zoning variance. You're not ever going to need to go for a community benefits package or whatever you need to do. It's all just ministerial. Then these rules just don't apply. You know, so hopefully that does, you know, that takes a lot of your projects sort of off the table in the sense that they're just require ministerial staff level approvals. But you don't need to worry about those things. The other thing, I don't know if this is relevant for anyone on here, but you know, the law does apply to, you know, pretty much every government contract and franchise. Competitively bid contracts don't count, but government contracts and franchises themselves, they absolutely do. So, you know, to whatever extent, you know, that impacts your business, again, you've got to pay attention to this law. Then in terms of the limit, I mean, we refer to it as a $250 limit on campaign contributions before this rule kicks in, but it's not, it's a lot more, it's just a lot more complicated than that. The limit itself is a combined, you know, it's an aggregate limit from basically all of the players on the deal side of things, right? So the corporate entity itself, the lobbyists, the land use attorneys, the employees who work for the developer, who are interacting with people at the city, everyone together has a $250 limit, right? So if your you know, your land use attorney makes a $249 contribution, and your internal government affairs person makes another $249 contribution. Combined, that's over the limit, and this rule kicks in, and you know, disqualification is going to flow from that. So it's very, I mean, I don't want to say it's a prohibition, it turns into a prohibition, but effectively, you know, it is like a prohibition, as in you're not going to want anyone in your deal team, you know, on your deal team to be making campaign contributions, because it is so easy to go over that aggregate limit. That is, you know, that's it's just very easy to go over the aggregate limit. So that's definitely something.
And that's, I think, the most important point. I know certainly, again, we've been giving advice under this law for 25 plus years, and this is where kind of most questions have happened. But this is where the law, in our experience, is truly a trap for the unwary. That you not only have to worry about, obviously, your business making contributions, those you kind of can control or certainly have knowledge of. You have to worry about those employees who are working on the project, who are interacting with the council or the board of supervisors about the project. Their contributions count, contributions from other employees don't. And then, but it keeps on going. As Matthew mentioned, it's outside consultants. Now, okay, your lobbyist who's representing you, that one you might kind of think of. The land use attorney who's representing you in the project, that what you're going to think of. But the architect, the geologist, the sound engineer, the EIR consultant, if those people are interacting with the council offices or the supervisor's offices, then contributions from those people and their firms also count. And that's obviously, and that's where we've seen over the years, a council, or well, a planning commissioner would be disqualified because some architect gave, right? And the developer didn't know that the architect gave. And the architect might have gone to a fundraising event because the planning commissioner was his or her next door neighbor, right? Not because of the project. And the other thing I want to make certain that everyone understands is it totals all these contributions. So the limit's 250. So you can give 250 and not trigger recusal. But if the project LLC gives 250 and your land use attorney gives 10, then there's recusal, and the law has been violated, right? It aggregates contributions from all of these entities.
Does it require interaction with the elected body, or could I never say a word and just send a contribution in? And another part of that question is, if I give a contribution to a candidate, I tell them where I work at the landscape company, the architect company, but the elected person may not know that I worked on that project.
So yeah, it requires some type of interaction with the council office, the council person, the supervisor's office, whatever. I mean, a letter, an email, a phone call, whatever the case might be. You know, certainly we would recommend that if it's your architect on the project, you know, like assume that architect is going to be in contact with the council office at some point, you know, or maybe a geologist wouldn't. I mean, you guys are in the best position to know that. So the law, and part of the question is the law has written into this concept of know or have reason to know, that the council person can't vote if he or she knows or has reason to know that there's a project and knows or has reason to know about the contribution. So about knowing the contribution, it's deposited in their campaign account. They're signing their campaign reports. So once that campaign report is signed, they're going to be on constructive knowledge of all those contributions. And, you know, knowing that, you know, that this architect or this geologist is working on the project, that's where this law is just a trap for the unwary. Yeah. Right. And that question right there has not, to our knowledge, been answered in an FPPC regulation or been answered by an FPPC advice letter, meaning the politician knows about the contribution because she signed the campaign report or, you know, whatever, and she knows it's from an architect. She didn't know that the architect was working on this project and the architect, didn't contact her directly. That question has not been answered of whether that would, in that case, where they don't know the architect is working on the project, has triggered recusal.
That's why this law is so crazy.
Hey, guys, under employment law, can I even tell my employees what they can do from a contribution standpoint legally?
Yeah, that's a great question. We will, one of our, compliance advice, and you can be a little permissive or you can be very aggressive, we recommend either having your employees basically do a pre-clearance, so if they want to make a contribution, they've got to pre-clear it with your legal team or with your compliance team, right? And then you give, you can say yes or you can say no to the contribution, or you can just straight up outlaw contributions from employees. Like, I mean, that is allowed. I mean, you'll have your sort of, whether employees would be okay with that, because you're in effect taking away their, one of their First Amendment rights. But we have cleared that with employment attorneys, and if you as a company feel like it's not worth the risk completely, then you can put that in your employee handbook and your employee contracts, and you can just say, hey, as part of joining our company, you're not allowed to make campaign contributions because effectively the risk of you making a campaign contribution could sink one of our projects. So that is allowed, and that is something that we deal with our clients a lot on the compliance side of things.
Even if they're at-will employees.
Even if they're at-will employees, yeah.
Hey, on the flip side, I'm dying to ask this question, so I might be getting ahead of myself. But on the flip side, like, let's say one of the carpenters union, right, shows up and is opposing a project.
Yeah.
And they've written however many thousands of dollars of checks to the elected officials. They can vote on that.
So that's a good question. For an opponent of a project to be able to trigger recusal, right? They, like you said, they have to make a campaign contribution, but they also have to have a financial interest in the project itself. And I mean, generally speaking, unions don't have the type of, there's pages and pages of laws and regulations that explain what a financial interest in, and just generally speaking, the unions don't have financial interest in these specific real estate projects enough for their campaign contributions to disqualify the elected official that they gave to.
Even though they're doing it to obtain a PLA or whatever they're going after?
For the most part, yes. I mean, there could be certain circumstances where that might not apply, but for the most part, yes. Jim, I don't know if you have any more.
We have, again, I was going to keep saying this. So many of these questions have come up under 84308. So we looked at that question not that long ago, and the question is, will this project have a financial impact on the union, right? Not the union members, right? So even if there's a POA, and even if the carpenters know that X number of their members are going to get jobs because of it, so then it is, will the vote increase dues to the union, right? Like, and then that's just kind of this crazy factual question. But as a general proposition, though, the union members are going to get something out of the project financially, but the union itself, unless there's some reason to believe that this project is going to actually increase union membership or increase, dues. And usually that answer is going to be no, right?
Well, I mean, I would anticipate the answer is yes. I mean,
well, then they would have a financial interest and they're a participant and their contribution is prohibited. Or
right. I mean, under a PLA structure, the dues are collected out of members who might not even be part of a union. And if they don't stay in that job for 5 years, the union gets those dues.
And there you go. Then that would be the argument. There is a financial interest, which means, and remember, there's always two parts of this, is that the council person who got that contribution from the council, from the union, and well, let me just kind of say, you can sort of make this argument, and I'm going to tell a story about that. But so the council person who got the contribution from the union can't vote, because you're going to make the argument the union is going to benefit from the PLA. But remember also there's this prohibition, right? The bullet point on the slide that while the project's pending, if you're a participant, anything over 250 is prohibited, right? Regardless of what happens, with the vote. So yeah, just a quick story about how this law sometimes comes up, and it could be relevant to this example is the day of there's an evening hearing before the council, 2 or 3 in the afternoon, late enough that the council person and the city attorney won't have time to respond. You send in a letter. Here's a contribution from the union. Here's the PLA. This is how, if this project's approved, there's going to be more members. The union's going to be able to keep the dues. Therefore, it's a financial interest. The more complicated the question is, and you drop that letter. And again, obviously, we've had several clients who have done this. You drop that letter the day of the hearing. It causes enough confusion, especially now with so much focus on this law. Either the council person is going to say, I can't vote, or the city attorney is going to say, I need more time. And anyway, so just a little maybe strategic suggestion of how you might raise that issue.
Cool. Okay, so then just back to these aggregation rules and who it applies to, and who you need to watch out for. Jim alluded to a few of them, but we say that for real estate project, the developer itself is a corporate entity. The developer's major owner, or majority owner rather. So if anyone who owns 50 plus 1% of the developer, the LLC set up for the purpose of developing a property is going to come within this $250 aggregate rule. The LLC's controlling owner will come within the rule. Then any person who quote unquote directs and controls the contribution decisions of the developer and or the LLC, right? Just generally the president, but can be other people. They're gonna come in with this $250 aggregate limit. Any LLC or other business entity owned or controlled by the developer. Again, and this is just if you're trying to get around this rule, you've got to be very careful about what entity or person you try and use to do that, right? So if you're the developer, you've got an LLC that holds title to the property, and you run your expenses for the project out of that LLC. The developer itself is going to be effectively prohibited, but under this $250 aggregate limit. The LLC itself will as well. So you think, well, I've got this other LLC that's doing a project in Northern California, whatever. Like, let's just have that LLC make the contribution. No, like that LLC, because you control the contribution decisions of that LLC that's in a different part of the state. That is not a way to get around this rule. That entity comes within the aggregate limit as well. Then any employee who represents the LLC and the developer before the council or the board, like we mentioned, outside consultants, lobbyists, attorneys representing the developer of the project. Then the firms, the consulting firms, the law firms, the lobbying firms, they are also going to be covered by this law, right? So if a lobbyist is working on this project, and then obviously the lobbyist comes within this $250 aggregate limit, but so does the lobbyist firm itself, right? So the firm can't make a campaign contribution, without having to worry about this aggregate limit. Then finally, any neighboring property owner who submits a letter of support or otherwise testifies on behalf of the project. This is definitely a trap for the unwary as well, right? I mean, I know, a lot of you hire, community affairs people to go out into the community and try and get support. And depending on the project, sometimes you find it. If you have let's just say you've got a wealthy neighbor who owns a house next to your development, or close to your development, or within 1,000 feet of your development, and for whatever reason they are supportive of the project, and they're wealthy, and so they've made a campaign contribution, and you convince them to write a letter of support to the council. If they do that, then this rule can be triggered, right? So you have to be, your community relations people need to be a little bit careful about who's made campaign contributions, in the surrounding area, and who is submitting support letters, because you can get community support and then suddenly you've inadvertently triggered this rule because you engaged with the neighbor who'd made a campaign contribution. So that's just a, a big, we'll say, trap for the unwary.
So if I don't like a competitor's project down the street and I've given money to folks, I can write a letter of support and recuse the people that are voting on that project?
Yeah, I mean, there's a little more to it than that, but yeah, I mean, if you're
Stupid, oh my God.
Yeah, if you're within 1,000, if you live within 1,000 feet of the property and you make a campaign contribution to, a city council person that you think would support the project and you're trying to kill the project, you could do that. Now there's this whole know or has reason to know, right? So you'd have to somehow signal to the city council person that, you have a financial interest in the project, right? Because the council person needs to, again, know or have reason to know that this would be a disqualifying contribution. So that's sort of the complication in that strategy. But as a general matter, yeah, that's possible. And we'll in a little bit, we'll get into sort of kind of a couple of ways that you can use this law offensively as opposed to defensively.
But the neighbor down the street doesn't have a financial interest.
Well, if they're within 1,000, so if their house or a property that they own is within 1,000 feet of the development, they would have a financial interest. If it's further away, right? So that's just going to be very close surrounding neighbors. If it's further away than that, then yeah, they generally, unless there's some other detail that we don't know about, they don't, just by operation of owning a property that's over 1,000 feet away does not necessarily, create a financial conflict of interest. So, okay.
I mean, so the short answer is basically we have to put all political donations on hold until the results of the CBIA lawsuit.
Or give them to the BIA PAC.
Or give them to a PAC.
Go to PACs.
Or weaponize them and against the person you don't want voting on your project.
So
Yes.
Matthew, to follow up on that, can you give us, for those of us that have to leave at 1, can you give us follow up on what you just heard, which is give to the PAC, blah, 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 which does work?
Yes.
We
Yeah.
we can insert our advertising right now at John Larea.
Yeah, so that's a great point. So right, so like like they say, campaign finance money is like water, it always finds a way. So there are some ways, and we have our guesses, and we've already kind of seen how how people are going to get around the law. One of them is your classic trade association PAC, just like BIA, right? BIA will be one way to for you to contribute money, and then BIA giving to pro-development, supporting pro-development candidates. That is totally allowed. And we anticipate that trade association PACs will become even a bigger player, in the upcoming elections, because they're entities that are not really affected by this law. So, John, I don't know if you want to talk about the PAC right now.
No, I'll just jump into that. That is something we have discussed. The PAC, in the past, the BIA has hosted typically breakfast fundraisers for particular candidates. We think there's an opportunity to host those very similar formats, but your contributions go to the PAC. And we have an opportunity based on what we do every day and thinking about, who are those candidates that support housing. We can make decisions on a PAC based on what's in our bank account to support those candidates that support housing. So our opportunity is to encourage more contributions, have those dollars in our bank account, and then make decisions based on who supports our industry. So we'd appreciate you to continue your support and think about the budget that you had previously when you'd support directly and support the PAC instead. We'd appreciate it.
And to jump on that, this is Tyler Sandstrom, the chair of Build SD PAC. Build SD PAC is also another avenue where contributions could be made more on the smaller donor amounts. And we focus on local races in San Diego County of the smaller cities where smaller donations go further. So Build SD PAC is also another avenue where funds can go to help get candidates elected who are also pro-housing.
And Tyler, we have a number of smaller cities that we're very interested in this year, as well as we thought this was going to be a quiet campaign season, and it has totally flipped. We will have a lot of involvement in this next season. So,
And if I could even push that point a little further, so as you said, this law is really complicated. The 250 limit is so incredibly low. There's all these traps for the unwary. You know, a little contribution can inadvertently do it. What we see and what we're kind of recommending is there are some contributions that definitely don't trigger this law. Contributions from spouses, contributions from employees who don't get anywhere near the project, and contributions from vendors who don't get anywhere near the project. So, you know, you could fundraise from those sources and just don't touch any of the people who might be covered, right? Don't get near the 250 limit. But independent expenditures is what it's all going to be all about. If the real estate industry wants to continue having pro-development council people and supervisors, it's going to be the BIA PAC taking lead on doing independent expenditures everywhere. And that's really kind of our legal advice. The safest option, the best option is to have your political money go to, you know, the BIA PAC in your county, or, you know, maybe there are other PACs, you know, which are bona fide, above board. It's not a new, I mean, you know, there are a lot of new PACs being set up to do independent expenditures. But, you know, the BIA PAC that's been around for a long time, it's bona fide, it's done independent expenditures, it's clearly pro-development. That's really what we expect to see over the next year as more fundraising happens, and then as the March primaries happen. So
what do you suggest we say when we get solicited by an elected official that just don't quite understand this?
Here's the phone number of the governor, call and get mad at him for signing this law.
Well, and to follow up on Lori's comment, Supervisor Anderson has some very, we'll call them novel, inventive, and arcane mechanisms in mind.
Yeah.
And I am deeply nervous
Disturbed,
about
right?
them.
Right.
Lori, do I have that right?
Yeah, that we do have one elected official that says, oh, you're just going to let me lose? I can just give you the money back. And so then there's a couple of questions of when does the 12 months start prior to the vote? Is it when you submit your application, or is it when it's noticed on an agenda? When does that 12 months before the project is decided? And then and Supervisor Anderson will say, I'll just give you the money back. How do they actually give the money back?
No, good, great. No, definitely great question. So, I mean, the prohibitions apply, the prohibitions on making the campaign contributions and being solicited apply from the time the application is actually filed until 12 months after the final decision, right? So, I don't know if there's a specific example, Jim Whalen, that you have about Joel Anderson, but obviously you've got to be very careful about what the candidates tell you. And that's another sort of trap for the unwary that you have to be careful of. You know, the candidates, of course, are looking out for themselves, and you know, they're trying to raise as much money as possible, right? And so they can make promises that, hey, I'll refund you the money, but once you make that contribution, once you give them that money, that's in their control, right? And they may, you know, come when your project comes for a vote, right? Maybe it's coming during the heart of campaign season, and he would, you know, Joel would much rather just keep the money and not vote on your project, right? Even though, and your project may very well need his vote. And you tell him, well, you know, you got to give it back so you can vote. And he's like, I don't want to give it back. I just won't vote. I don't care. You know, not that he would say, I don't care, but he would just say, you know, it's more the money's more valuable to me in my campaign than it is to, you know, voting on your project, right? So it's an important one, although there are, you know, the 30 days to cure, right? The 30 days from when the candidate or the elected official knows or has reason to know that this is a problematic contribution. They have 30 days to give it back. You know, and that clears the disqualification issue, but only if they give it back. And so you got to be, once you give that money to them, then, you know, they have the control, right? You know, possession is 9/10 of the law, right? It's that type of.
Can I read you 2 sentences? This is what they say we should do. All credit donations will be allocated in the following sequence. First, to Anderson for Supervisor 2020, up to $850 per election. Second, to Anderson for Supervisor 24, up to $1,800 per election. Third, the remainder to Anderson for Central Committee 2024. And that's when he stops.
Remember that, since those are all Joel Anderson's committees, a contribution to any of those committees triggers this rule.
So the other,
Yeah, so it doesn't really matter how he allocates it.
Thank you.
Yeah.
and there was another supervisor who used to be raising money to run for state office. So I think was giving some similar comments to proposed contributors. The other problem with the 30-day cure, which was written into the law to protect the law from constitutional challenge. It's 30 days from when you know about the contribution and 30 days when you know about the project. And with planning commissioners, and there's a whole reg about when the agenda packet comes out. And I think this is definitely a source of confusion. A lot of planning commissioners truly, they're not allowed to talk to the proponents, right? Or they don't know about the projects until they get their agenda packet, especially smaller projects. But with politicians, most of you, that's the first thing you do is meet with the politician and talk to them about the project. So the 30-day cure is not going to work, at least in our experience, the questions that we've gotten, it's not going to even work because you've already spoken to the politician about the project. So they know about the project, you write them the check, basically the 30 days starts ticking right then. And this concept that they can later give it back once it gets agendized is just completely inaccurate.
Do you lose the protections if you give the money to the BIA PAC with restrictions? So for example, if I give the BIA $10,000 on the condition they give it to the mayor of Escondido, are we still protected or not?
So that's a good question. So no. So you got to be careful of that because there's a whole other area of law in the PRA about what we call earmarking. So in that situation, if you give, I don't know what the contribution limits in Escondido, but let's just say it's $5,000. So you give the BIA PAC, say, hey, here's $5,000. Please make a contribution to the mayor of Escondido. The law, by operation of the law, the contribution would still be from you. It would not be considered from BIA PAC because you are entering into some type of soft agreement with BIA PAC for them to pass through that money to the mayor of Escondido. So that would not work, and would still trigger this rule and some other campaign finance violations that you just don't want to, you just wouldn't want to touch if the truth ever came out. So you got to be careful of that. But giving to the PAC, giving to BIA's PAC, and knowing that they would support pro-development candidates, and then at some time in the future making recommendations to the PAC, to the PAC's board, saying, hey, it would be great if you supported these candidates, but do whatever you want with my money. And that's the true nature of things. That would be
how it works. Yeah.
That works. Yeah, that's how.
And I'll just jump in. As at the BI PAC, we wouldn't accept money if someone tried to say, hey, you have to put it here. We wouldn't do that. We wouldn't accept it. Period. And
But we would be very aware.
But we always are interested in who are the pro-building candidates that we need to know more about, right? I mean, that's the whole idea. The BI PAC has existed for a long time. We support pro-building candidates, period. And we have a track record of doing so. So that's important to us. But we would not take money if someone directly said to us, you need to put it here.
Well, this is Dave again. Of course, I wouldn't do that to begin with. I just want to make sure I understand the rules. Right. But for example, could I give you $5,000, say, spend it however you want, but I'd really like you to write a letter in favor of my project?
In that situation, you're asking BIA to write a letter in favor of your project?
Yes.
Yeah, no, that's fine. I mean, you can make a campaign contribution. I'm sure I would guess BIA wouldn't have a problem, with that type of situation, functionally, but as a legal matter, that would be fine.
And the BIA PAC is a separate organization from the BIA organization. So.
And just so you know, the BIA corporate side has a program called Project Greenlight. Their program activates supporters for projects, and it's a whole separate program from what the PAC does. It's called Project Greenlight. Lori has a lot of information on that.
Now, I would say the BIA PAC would take the donors' comments serious in and understanding why they would like to support somebody and likely be aligned with you.
Likely.
Yeah, I mean, and which of course makes sense, right? We're all on the pro development side, so.
When we see a lot of interest in Oceanside, and we know that we need more pro-business, pro-development candidates in Oceanside, we're going to invest there.
Exactly. Okay, so what? So I mean, we're almost hitting 1 o'clock, but I figure, I mean, there's a few other points we can make, but why don't we make sure everyone's questions are getting answered? Anyone else have questions out there before we hit time?
I have a real quick question. I think I know the answer based on your description of what the law was originally written to do. But if you have an elected official that also serves on a board like LAFCO, if you've given to them, are they precluded from voting on your project at the LAFCO level?
Yeah.
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 And Matthew, you talked earlier about how to use this as an offensive tool instead of responding.
Yes. Yeah. So there's sort of two. There's two ways to do this. One we alluded to at the beginning, which is effectively you purposely make a contribution to an unsupportive elected official or appointed commissioner. You somehow signal to them that you have a financial interest in the project, which depends on the details, and then in theory they would need to recuse themselves, right? That's when you take Jim's strategy of sending a letter 3 hours before the hearing and say, hey, they received a contribution from me, I have a financial interest, they knew about it, therefore they need to recuse themselves, right? I mean, we'll call it an aggressive strategy, right? And it has to be done correctly, but in theory it could work. The other way is just more of a due diligence thing, is where you find contributions from project opponents who have a financial interest and you demand recusal, right? So that's that situation. Actually, we have that situation in LA right now, where a developer is building a giant 450 unit apartment complex. Across the street is a wealthy landowner who is very politically active and hates the project, just hates the project. Clearly that owns the property across the street, so clearly has a financial interest, is politically active, and has made campaign contributions to city council people, and this project's going to go before them, and they're gonna, we're gonna most likely, I mean, there's some political ramifications, but as far as a legal matter, we're going to try and use that to recuse some people that we think are going to vote against the project. So knowing your opponents, knowing their financial interests, and knowing their campaign contributions can really go a long way towards using this law at least a little bit to your advantage, since it's so disadvantageous otherwise. But those are the two ways. So okay, then.
It is 1:01. We appreciate everyone coming today. This is a very important topic. I think Matthew said that he would stay a little bit longer, and Jim, if there are some more questions, but appreciate everyone coming today. And so it's important, and give to the PAC.
Give to the PAC. Yeah, no, happy to stay on and answer any questions that anyone has, but
Thanks a lot.
now that we've hit time, yeah, of course.
Thank you.
Okay.
So do you have any suggestions for best practices on directing your employees? I mean, you said you could tell your employees.
Yeah. So like we mentioned, I mean, you can put controls on your employees, right? Now it's only as good as them following them, right? I mean, right. So if you institute a policy where you say, hey, no campaign contributions because we don't want to violate this law, you put it in the employee handbook, you put it in their contract, right? But then the employee is thoughtless or whatever and makes a campaign contribution, it doesn't inoculate you from an FPPC enforcement matter. It does not inoculate you from disqualification rules. But at least in the enforcement context, in the FPPC enforcement context, where they go after you, you can say, hey, wait a minute, we did the best we could. We told them not to do it. They signed it. We just didn't know about it. Right? And so that, we think that goes a long way in preventing, prosecution, for the contribution itself. So that's highly recommended. Regular training session for employees and outside consultants is always a good idea, right? This is, again, there's just so many traps that they're wary on this, and people aren't always thinking about this law that, consistent training and consistent reminders to your employees and your outside consultants, especially for large projects where over time the deal team changes, right? Where you hire a lobbyist to do this thing, and either they do it or they don't, and then you bring in another another lobbyist for the second phase of the project, right? So when the deal team consistently changes, someone's got to be aware of these laws and still tell all the new deal team members, right? Employee turnover, all these things that can happen, right? Everyone needs to be aware of the law. So regular training sessions is a good way to do that. Then your contracts with outside consultants, there should be, we have draft language for this kind of thing, but there should be, language in there that says, hey, you're aware of these laws, not to make a campaign contribution. Basically, if you do, it's on you. So that's, again, be very, very careful about the contracts that you're drafting up and making sure that this law is almost, specifically called out, so that everyone who's signing the agreement knows who's responsible for what and what the rules are. It's a helpful way, again, just to, because the education is 90% of this, right? If you educate people, they know not to break these laws. So that's another great way to do it. And then like we mentioned, just don't trust politicians and how they characterize the law. They have their own agendas, for better or worse. They have their own agendas, and they want to raise money, and they may not care about your project, right? So they're just going to tell you what they think will raise them the most money, even if it's not legally sound, or if it's to your disadvantage. But that's the quick, compliance best practices.
Certainly would be on your employee if they gave a contribution and then you were not, the politician wasn't eligible to vote on you, and you sit there with no project.
Yeah, I mean, right. That's worst case scenario, right? You the developer did everything right. You did everything right, right? You knew about the law at the forefront. You trained everyone. You put it in your contract. You told everyone repeatedly. You didn't make any contributions yourself, and then some wayward employee or some wayward consultant's like, well, it's my college best friend was running for city council. I wrote him a check. Big deal. It's like, well, that is a big deal. The whole project just got sunk, right? So the consequences of this is, they're significant. They're significant. So,
any other questions? Well, Jim and Matthew, thank you very, very much. You really shed a lot of light on this. We should have some clarity for our members, and we are glad that we were able to record it so that anyone else that needs to have this information, it will be available to them.
Great.
Thank you very much for your time, and you've always been very responsive to us when we called. Thank you.
Love to help. All right, take care, everyone.
Okay, thanks.